Welcome to this training tutorial on IT contracting license agreements, software contracts between software producer and digital preservation user, created by Sylvia Yankova and brought to you by the Timbus project. This training video, broken into two segments, will demonstrate the relationship between a software user and a software provider to ensure a contract for legal and effective digital preservation. Today, companies must digitally preserve their business processes in order to understand and reuse archived content in the future. Business processes can be complicated and require the preservation not only of a diverse amount of data, but also the preservation of the software used to create and to read that data. When companies do not themselves have the technical means or expertise to perform the digital preservation of business processes, they may outsource digital preservation to a third-party provider. A third-party digital preservation provider can ensure that archived data is rendered into a readable form in a number of ways. The provider might migrate files from obsolete formats to up-to-date formats, or the provider might emulate obsolete systems on newer platforms. Migration has already become an important IT service, a service that might include exchange of computer systems, data consolidation, or data migration. Additionally, a third-party digital preservation provider must also ensure the secure storage of archived data and also provide a means to access and exhume that data over time. This training video presents and explains framework contracts, a set of agreements and conditions that constitute the fundamental rights and obligations of the digital preservation user and the third-party digital preservation provider. Such a contract must be carefully written in order to meet interests and expectations of both parties. The contracting parties must take into account a variety of issues. This slide shows a number of principal issues that must be addressed in a third-party digital preservation contract. The terms of software licenses, any intellectual property rights within the archived data, any intellectual property or other rights in databases, and data protection restrictions spanning multiple national jurisdictions. Before a third-party digital preservation provider can execute digital preservation, the company must have the appropriate licenses and sub-licenses. The contract must establish that all digital preservation actions taken will be within the constraints of relevant copyright and data protection regulations. These concerns are especially important in an outsourcing context. The contract should cover all of the following concerns. Software licenses and use rights. Both contracting parties must have the correct rights to use any software that they run on appropriate hardware. It is important to note that the installation and implementation of software into a system, as well as loading RAM, usually requires consent from the software copyright holder. When agreeing on contract terms with a third-party digital preservation provider, all required software rights must be carefully determined. Any copyright protections that might exist within the contents of archived data must be observed. While there may not be any copyright on the preserved data as a whole, the independent components may have copyright restrictions within them. When the company, or digital preservation user, is the author of the works within the collection of data, it must grant explicit permission to the third-party provider to reproduce the content in digital form for the purposes of digital preservation. When the copyright is held by someone other than the company, decisive consent must be obtained in order to execute digital preservation. Database rights must also be considered. During the process of archiving digital content, existing databases are populated with new information, and additionally, new databases are created, structured, and administered by the digital preservation provider on behalf of the company. In the event the digital preservation provider creates new databases, a clause must be written into the contract to agree on the copyright ownership, especially at the determination of the contract. Data protection must be strictly observed in the execution of digital preservation. The contract should adhere to data protection law from the company's home country, as well as make allowances for different legal requirements from other countries that could pertain to the preserved data. In some cases, It may be simpler to observe some non-mandatory data protection provisions in order to circumvent variations in data protection laws across jurisdictions. Lastly, due to the long period of time required for the digital preservation of business processes, contracts with third-party digital preservation providers should contain a clause called a Change Request Management Clause that allows for adjustments to the contract and its terms in order to accommodate future technical and legal developments. This Change Request Management Clause holds particular importance because without it, the process of digital preservation may be disrupted in the future and much of the preceding preservation work and effort lost. In addition to the legal aspects that must be integrated into a contract with a third-party digital preservation provider, technical requirements must also be specified. In order to stipulate the expected performance and detailed obligations of technical services, it may be necessary to include a Service Level Agreement, SLA, as an annex to the contract framework. An SLA can establish in-depth regulations of the service conditions to ensure the continuous provision of service and to describe their type and scope. The SLA can also set penalties in the event of insufficient or non-performance. Effective SLAs can ensure required ongoing services at a constant specified level. The terms of software licenses can significantly affect digital preservation and must be addressed whether digital preservation is provided by a third party or performed locally. A software license is a contractual agreement between the copyright owner of a piece of software and a software user. It encompasses ownership of rights, permissions, and restrictions to the use of intellectual property within the software. The license allows the user to execute certain agreed-upon acts that would otherwise constitute infringement of the copyright owner's exclusive rights. The license can grant either general use of the rights in the software or only specific uses. The license can establish a time restriction on the permission to use the rights by imposing an expiration date. Permission to use the rights can also accommodate future technological developments. Software licenses offer a valuable opportunity to establish rights for software users to support the long-term digital preservation of content created in certain copyright-protected software, especially porting, migration, and emulation. Software users should not forget the time-limited nature of some licenses. When a license expires, the user no longer owns the right to use the product or to perform certain digital preservation actions. All reproduction and migration must be performed before the expiration of a license. Performing any of these actions past the expiration date of the license will result in infringement of the copyright owner's exclusive rights. It is important to remember that the expiration of a license will prevent the redeployment of digitally preserved material. Therefore, in order to redeploy this material, the authorization of the rights holder must be granted. This is the end of part 1 of this training video. Please watch part 2 of this video to continue the tutorial.